Just to give you a brief background on this session, digital issues have affected different parts of our life. In fact, digital infrastructure and digital services are now considered as key determinants of a country's economic well-being. In this context, it is our pleasure at INSET 2021 to invite Dr. Maheshwari, who is a scientist and coordinator and head cyber law, Ministry of Information Technology. Over to you, Mr. Maheshwari. I won't take much time here. And for the participants, for the fellows and other organizers, if you have any questions, please type them in the chat. So I will now request Mr. Maheshwari to take the floor. And any fellows who have been meditating, you are now requested to come back and join the session as
well. Yeah, so thank you, Prateek ji, and thank you, Amrita madam. Thanks a lot for the India School on Internet Governance. Thank you also to ISOC Chennai, who is probably organizing this chapter. I also understand that it has been a hectic day. So in a way, I'll therefore keep my topic light in the sense that the things which I'm going to talk about are more or less known to you, which is primarily the cyber laws in the country. And I'm sure, my predecessors who must have been here must have also talked a lot about the privacy issues, the cyber security issues, the cyber law issues. So issues are more or less going to be on the same lines, except for the fact that I, at present, do represent the Ministry of Electronics and IT as head of cyber law. Of course, personally, I'm not really from a law background. And to that extent, I always see the law from the common sense perspective. And of course, on a day-to-day basis, the powers that have been vested with government, particularly in the context of Section 69A, wherein I was the designated officer for about more than 4 years, till about a year back. And of course, I should say the court, a number of court cases where this ministry is made party or government is made respondent. And of course, the intermediary rules 2021, Information Technology Intermediary Guidelines and Digital Media Ethics Code 2021, that's how we call it. So I was an instrumental person in seeing these rules, in enabling these rules becoming or seeing the light of the day. So this is where I'm coming from. Now, as far as the topic today is concerned, I have been asked to talk about the digital policy legislations in India. And as I said, that's where I will be primarily talking about the IT Act, the way I see it at least. So as you are aware that Information Technology Act 2000 came into existence in 2000 and is one such law, which is a all-comprehensive cyber law available as on date. In fact, this is the only law, in a large context, this is the only law which does cover all the lateral aspects, all the laterals in the field of cyber world. Beyond that, there can be certain, I should say, domain-specific laws, rules, and regulations which exist. So this
Sir,
is
I think you're muted. You went muted just right now.
Oh, did I?
Now you're okay.
I'm sorry.
You're audible, sir. Now you're audible. Go ahead.
Yeah. So this is one single act which covers the whole issue of e-governance. So when the act was initiated, there were issues of parity of electronic records with the physical records. And this is the act which gave this parity. It gives recognition of digital signatures, as amended now as electronic signatures, to ensure that the law continues to remain technology agnostic. It provided the criteria of in fact, it created the institutional mechanisms for working of the CCA, various CAs, certifying authorities and controller of certifying authorities. It created policy for electronic service delivery in the country. And hence, in a way, it created a large enabling environment in the country for the good of e-governance and for the good of e-commerce in the country. Of course, the Act has a Schedule 1, wherein certain documents, transactions which are presently not covered under the IT Act, and hence these documents, even in the electronic form, do not get parity and hence are legally not recognized in spite of the IT Act being there. This includes negotiable instrument. So I understand under the Negotiable Instrument Act, there are some 3 categories. So promissory note, for example, is one such category which is not included in the IT Act, which has been excluded in terms of the scope because of its inclusion in Schedule 1 of the IT Act. Similarly, power of attorney, a trust, a will, or any contract for sale of conveyance of immovable property or any such interest in such property. And to that extent, it goes much beyond the sale of conveyance of immovable property. So something which relates to the mostly, to the property or 1 or 2 aspects in terms of the Negotiable Instrument Act and the will and the trust is what exactly is excluded as of now from the scope of IT Act. IT Act also provided actually defined various cyber contraventions. So IT Act as of today has not only defined, has defined cyber contraventions as well as has defined a number of cyber crimes. With respect to cyber contraventions, for example, it says unauthorized access, unauthorized downloading, copying, introduction of malware, physical damage to the computer resource, denial of service, stealing, destroying of computer resources or the computer data in any way amounts to various contraventions. And when I say contraventions, there is an adjudicatory mechanism which has been created. All the IT secretaries in any state of the country has been declared as an ex officio adjudicating officer for the purpose of adjudicating all such contraventions. And they can fine, they can levy penalty, or they can provide a compensation up to rupees 5 crores as has been provided in the Act. However, if any of these contraventions are conducted with a clear intention to disrupt, or there are other cyber crimes which have been defined, for example, stealing, or which are relating to identity theft, or which are relating to impersonation, then these are considered as cyber crimes and therefore are dealt by the law enforcement through the law enforcement agencies. And the Act provides a penalty up to 3 years, and all the sections, all the crimes for that reason are cognizable and bailable. Act also provides crimes relating to obscenity, video voyeurism, including sexual explicit act, child sexual abuse material, publishing or cause to be published, transmitting or cause to be transmitted. The Act further goes on to define further cyber crimes, which are in the form of terrorism. And so hacking and terrorism cyber terrorism has also been defined as crimes, with particularly cyber terrorism being attracting much higher penalties. The Act also provides offenses by the companies and the liability, and therefore holds accountable the companies and their management in case it's proven that they were in connivance to the offenses, as I mentioned earlier, have been they were in connivance while such offenses were being conducted. In the absence of a personal data protection law or a comprehensive privacy law, even as on date, IT Act continues to provide the suitable provisions for the protection of sensitive personal data, particularly when it is dealt by body corporate. So other than government agencies, if anyone is collecting, processing, analyzing, storing, transferring to any other body, either within the country or outside the country, the provisions of Section 43A relating to security of sensitive personal data, or there is another provision which is 72A, punishment for disclosure of information in breach of a law of contract. So intentionally, so while you have collected data by way of a contract, but you are intentionally violating the contract, then there is a criminal penalty as well, provided through Section 72A. In fact, the Act also provides the due diligence in a way to be followed by the people, by the organizations which have been authorized under the Act. So Computer Emergency Response Team, for example, has been authorized to collect a lot of information relating to incidents, or the CCA or the CAs, the certifying authorities, are collecting or are having access to some of the personal data by virtue of the Act. Then the confidentiality, integrity, and security of this particular data in the hands of such organization is also covered through a provision, Section 72. The Act at that time also, I mean, of course, as I said, I mean, Act came into existence in 2000, but has later on been amended in 2008. And when I look at the 2008 scenarios, the crimes, the overall digital ecosystem at the time is what the Act has really covered. But of course, a lot of water has flown. The way the things have happened, there is definitely a need to relook at the provisions of the Digital Act and to see whether, in what way should it come up. Anyway, I continue with that, the various provisions. So the Act identifies the critical information infrastructure, which has been defined, very well defined in the Act, and the notification of the same as the protected systems. So Act provides, therefore, for the proactive protection of the critical information infrastructure in the country, and that's being done through a dedicated organization, central government organization, which is NCIIPC, National Critical Information Infrastructure Protection Center, working under NTRO in the country. For the response, for the incident response, when things really go wrong, not only in the critical sector, but in any other sector, including the users, government, any private organization, any organization in the country, there is a 24/7 computer emergency response team, which has been carved out because of Section B of the IT Act. And CERT-In, being the national nodal agency, has not only been empowered to seek any information about the incident from any organization or any service provider for that reason, they are also authorized to give any directions, issue any advisories relating to the cyber incidents and cyber security incidents. The Act also touches upon the examiner of electronic evidence. So in a way, it also empowers government to issue, based on the competence of certain laboratories dealing with electronic evidences, forensics, and notify them as the examiner of electronic evidence. So already about 10 labs in the country have been notified under this provision. Any act also provides powers to the governments. So some powers have also been vested with the government. Section 69 is a I should say a equivalent of phone tapping, which happens through the Telegraph Act. So Section 69 deals with surveillance, monitoring, and decryption. Of course, there are good amount of check and balance in any of the powers which have been vested, and same are true with respect to Section 69A, which deals with blocking of information, Section 69B, which deals with collection of metadata relating to internet and data flow from within and across, outside the country. IT Act is in a way extraterritorial. Given the way the internet works, being borderless, being with users having capability to be able to post anything, share anything from anywhere at any time and instantly across the globe. So Act also is extra jurisdictional. So it goes beyond the boundaries of the country and does provide and is applicable to even from crimes committed from outside, but if they impact any Indian resident in the, therefore, so the Act therefore goes beyond. Act also provides certain powers to the states, though IT is or on any online activity for that reason is, it's basically global. So even if we are looking at maybe in the Indian jurisdiction, Act cannot be the provisions of Act. Most of the provisions of the Act actually apply uniformly across the state. But as regards delivery of electronic services, the Act also empowers the states to develop their own electronic governance-based service delivery models. For implementing the Act, we have already enacted more than 40 rules, including the recent, as I mentioned, the IT Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which superseded 2011 rules, and the much talked about as of today, the SPDI, the Security of Sensitive Personal Data rules. So those are some of the rules which have been enacted courtesy IT Act. The Act remains technology agnostic. Any Act should, for that reason, be technology agnostic, and to that an extent does not take into account any specific technology. However, the nuances which may arise and which, if they are not covered, are the ones which do become the candidate for the update of the IT Act as and when it happens. Now, if we look at the overall scenario, the way the things have changed since 2008, there has been an increasing outreach, number of internet users, the profile of people who are using internet, the number of social media users, emergence of internet applications, particularly through mobile ecosystem, and hence the extensive personal and non-personal data collection and processing, which has started happening with the on-site of, with the mobile ecosystem emerging, emergence of big tech platforms, social media platforms, huge content being shared on internet. And there are, of course, lots of slides on internet as to what happens within a minute on internet. Ability to create and share anything from anywhere across at any time, increasing number and increasing variety and increasing complexity of cyber crimes, including cyber incidents, and the new technologies that are evolving each time, including the artificial intelligence, the Internet of Things, blockchain, cloud computing, quantum computing, and many more technologies which will continue to evolve. Today, therefore, if we look at, in fact, the Act, I forgot to tell, the Act also covers the regulation of the digital service providers, at the time being named as intermediaries. So certain definition of intermediary has been given, and the intent was that the platforms which are maybe otherwise not able to see or otherwise do not control the data which is hosted on them or data which is transmitted through their platform should be given the safe harbor provisions. So Act does provide safe harbor provisions to the intermediaries. But today, if we look at the way the intermediaries have grown, there is nothing called as pristine or a passive intermediary. There is nothing, no pristine intermediaries left. It's all about convergence. So intermediaries, social media platforms are moving towards the digital media. They're moving toward digital media publishers, and the publishers are moving towards the intermediaries. So for certain contents not being known to them. So the way the whole evolution is happening, there is definitely a need to relook and to look at afresh the way things, the way these intermediaries or the way these digital service providers, and particularly the ones which have really grown big, need to be regulated. And because all of them are, or many of them are operating from international, across the globe, you also need to be cognizant and aware of how and what rules are being governed. What rules are or what provisions are governing them. And therefore, there is always a possibility of maybe a mismatch of expectations, which is what leads to the problems. So maybe with this, I like to take a break and request, all my participants today to put their questions, and I'll try to answer, try to respond as much as possible.
Thank you, sir, for that brief talk. And I will just, if there are two questions here on the chat, and I will just restructure them for you.
Yeah.
The first question is by Subhendu. It's in a bit of legal language, so I'm going to simplify it for our non-law background people here. Okay. So essentially, the Indian Evidence Act 47A talks about when electronic signature can be used by the court to ascertain an evidence. And generally, it says that it all depends on the validity of the electronic signature certificate in determining, the authenticity of the evidence provided. So can you throw more light on, certain court cases or certain experiences of yours, where you have kind of used electronic signature certificate as an evidence in court, as well as, are you aware that have there been any parallel changes, based on, new technologies? Has there been any parallel changes back into the Indian Evidence Act? Just because, on IT Act.
So as far as Indian Evidence Act is concerned and the provisions which were amended because of the IT Act, I may not be able to talk much about, and I'll request, those who are practicing lawyers and are seeing, because so from a ministry perspective, we are, and the kind of, I should say, issues that are being thrown to us on a day-to-day basis are with respect to the policy issues. So, but on evidence, of course, there is a provision for the Section 65B certificate. And beyond that, if both the parties do agree for a certain piece of evidence, then in my own view, the same remains admissible. From the government perspective, the need was to create a credible, I should say, set of institutions who should be able to vouch for the evidence which has been analyzed by them. And for that purpose, as I mentioned, we have the scheme of notification of examiner of electronic evidence. Beyond that, I'll not be able to take it.
No worries. Thank you, sir. And now two personal questions, in general. And, again, it's up to you whether you want to take it or not. It is up to your discretion. So Mr. Raidu, who heads our ISOC Hyderabad chapter, has a question here.
Yeah.
As to whether it is legal for police to, stop, a passerby and then, examine their WhatsApp or, their intermediary platforms in case of there is some evidence of illegal activities, let's say drug trafficking or anything else. What is your opinion on it? It's a personal opinion.
Okay. So I understand there is a provision under Section 80 of the IT Act. So, but One, it has to be a public place, and there are certain conditions which have been put. So maybe I can just go through section 80.
Wow. You have
So
it.
powers of police officers and other officers to enter
Yes.
and carry out search.
Hmm.
So there is a provision, but not below the rank of inspector. Of course, it continues to be the same as the way any investigation can be conducted in the under the IT Act. And there is a possibility, but most of the time, my belief is that this particular provision, for that reason, has not been used. It's a potentially a provision which can be otherwise misused.
Thank you, sir. For the want of time, one last personal question. What is your favorite social media platform?
I don't have any favorite social media platform, but
or intermediary.
yeah.
That case.
So I completely agree. But what my favorite is the new rules which have been released by us, and I can definitely talk about any of the provisions of these rules and why they have been brought in, or any of them. So that's what I can definitely talk.
So,
all the social media for that reason are equal to us. You know, what is my personal preference may not be yours, so I'll not like to comment on this.
No worries, sir. So for the lack of time, if anyone has to reach out to you with any questions or anything, how do we reach out to you?
Yeah, so I can be reached out at rakesh@mighty.gov.in.
Thank you, sir.
I'll be typing the message.
Yeah, if you can just type in your chat. So Anushka, I'm a bit sorry, we are going here late with time, but
just take the question, Pratik. The last question, she's raised her hand.
Okay, Anushka. So we are now making an exception for you, and you are.
Hi, sir. I'm Anushka. Hello. I work at Medianama, and so I had a question on. So you just mentioned that there's been a lot of water has gone under the bridge on the IT Act. So I was wondering what opinions do you have on what updates could the Act use?
Yeah, so naturally, we are first of all waiting for Personal Data Protection Bill to be through, because that really determines as to what kind of I should say changes are being brought, because that will also be under the umbrella of Ministry of Electronics and IT itself. But beyond that, I definitely see that the way the whole digital ecosystem has grown, and as I mentioned earlier, the convergence of the services, the convergence of you being not aware of what is being hosted on the platform versus the publishers. So originators and the intermediary type of content, definitely there is a convergence. And to that an extent, any new law should definitely take into account from a service or a product that they are offering, digital product or digital services that they are offering, and they're creating maybe a suitable environment for them for doing business, as well as to take care of the government interests, which is primarily the user safety and the national safety. So that's one. And definitely today, with users being such a large stakeholders, you also need to take care of what their rights are and how do we protect those rights. So these are definitely the two things. Personally, I'm also looking for, say, whatever are the problems in the existing IT Act. And today, if you look at content management, for that reason, has really become a challenge. While 69A does provide some of the, I should say, options, the options under 69A are very, very limited. And any I should say, removal, disabling, blocking of content also has simultaneously a repercussion on the freedom of speech and expression. So there has to be a balance, but a faster adjudication mechanism, so that the rights, in fact, it's the problem of most of the users that while they, particularly when some material relating to their privacy is breached, you are really looking for a very, very quick action. And if that is not really provided under the law, the very fact that the content does go viral and the other users do remain anonymous, largely, mostly, therefore it impacts the users and their rights in a big way. So faster adjudication is yet another or means of how the adjudication become faster and adjudication becomes uniform. It's not just about content, it's also about many other I should say activities that the adjudication is required. Frauds are increasing, frauds have to be taken care of, cybersecurity incidents are increasing, so there has to be a coherent approach in dealing with the cybersecurity aspects. And we also need to take a decision whether should it be in the form of one single act, the way it is as of today, versus maybe different acts, the way different countries, in fact most of the other countries, have adopted. So 2000 scenario versus 2021 scenario, 2022 scenario, for that reason, happens to be quite different.
Thank you, sir. That was very insightful for all of us, and thank you for taking out time and even sharing your email ID for us to eventually get in touch with you.
Not an issue.
Thank you, sir. Now I think we would take this opportunity to now move to the poll. So to all the fellows, please.
Thanks, Pratik. Thank you, Rakesh ji, for sharing time on a Saturday evening and sharing all the perspective. It was very informative. Thank you so much. You've always come to INSIG and shared your views. So guys, I think it must have been a real hectic day. We had a lot of sessions, a lot happened. So we would like to know, I will share another poll, and I would like to, wait just a second. Just give me a moment. Wait, I am having an issue with
Meanwhile, all of you can take some deep breaths. As I said, you can take some deep breath. You can, look, stare away from your computer screen for a bit of time.
Wait,
till the time
Amrita, do you want me to launch
yes,
as
it
a
comes in.
co-host?
Yeah, I have the second one. It's just that I kind of have to wait. Yes, I've launched it successfully. So please do poll and share your honest feedback. This would help us to improve. I'm sure there has been a lot going in and you had to sit for all this while from 2 o'clock to nearly 6:30. I'm giving you another 1 minute, and I hope most of the fellows participate in the poll.
Please participate in the poll.
Yeah, whatever, good, bad, ugly, we'd like to see it.
Yes.
Okay, I think we are more or less stable. Now I'll share it. Let me share the results, and this is how it looks.
Phenomenal. 74% of them find the session insightful. Almost every one of them finds it insightful. Thanks a lot.
Yeah, as in, your honest feedback also would help. Your names don't come in. So even if you want something to improve, you could not understand anything, we'd be happy to hear from you. And you can also keep chatting in the WhatsApp group with your own queries, questions within, as a network, as much as you want within the group itself. You can ask questions. And if there are any specific questions you would want to ask any of the specific speakers, you have a few of their email IDs, or you can reach out to us and we'll try to help you. So we have a session tomorrow, which is the socials, and it is at 11 o'clock India time. Do be there. That is a fun session. And I think the Chennai team has many things which they are planning. So take a break and let's meet tomorrow at 11 o'clock. Thank you so much, everyone. Coordinators, if you can stay back for just 2 minutes, it would be great. Thank you. Others can leave.
Thank you.
Let me stop the recording.
Okay, thank you so much. Bye-bye.